Hi, I'm Eva from Homeowners Resource Group, and I'm here with Kera Reed from Ruskin Moscow Faltachek in Uniondale, New York. She's an estate planning attorney, and her firm also handles every other facet of law other than matrimonial, correct?
Correct.
Okay. Her and I had met a few years ago over a deal that had an estate where the owner's property that passed away was in foreclosure, and the proposed administrator of the estate came to my company for help with a short sale to get everything paid off that was owed on the estate with the mortgage. And then we were able to get everything taken care of, got him money to walk away with. We even covered, I think, his probate fees and things like that. And he walked away, a happy man. And we've done others since then, sometimes more complicated. But we're here to just talk today about estate planning, a lot of things that people don't think of. We're all one day going to die. We got to make sure we're ready for it and that we don't leave our family with a mess to take care of when we're done. So welcome.
Thank you. So good
Nice
to be
see
here.
you. Yep. So first thing I just want to talk about is everyone's big question is what's the difference between a will versus a trust? So can you just discuss what's a will and what's a trust and how are they different?
A will is a document that will transfer assets at your death. But before a will is valid, it has to be admitted to probate by a surrogate's court. So your will really does nothing until you are deceased and the court has approved it. Whereas a trust is active immediately. It is a living document and you do not need court intervention to make it work for you. It will start working immediately as long as it is funded. And that is the thing I have to say, that people have to fund their trusts, because a trust without anything in it is basically something that will catch assets after probate, and it may not do what you think it's going to do.
Okay, so when you say catches assets after probate, so if I want to include in my trusts my house, my life insurance policy, all of which you helped me set up in my life, I'm just going by example here, along with businesses, other assets that I have, what other things can be included and put in the trust that I may be missing?
So you can definitely put a trust, you can put a bank account, a brokerage account, you can put a business interest, a life insurance policy. The only thing you generally do not put in living trusts are retirement assets.
An example, a retirement asset is?
IRA, a retirement annuity, a 401k. You do not title those assets in a trust because then you will trigger taxation immediately.
Right, because then it's considered like, what do they call that? A disqualified?
It is not a qualified asset anymore.
Right. So as far as life insurance policies, bank accounts, things like that. So if you put it in a trust versus letting the will go through probate, what will happen upon someone's death that's different if you put it in a trust versus leaving it in a will for somebody?
So leaving something in a will means they have to go to the surrogate's court, get permission from every single relative. So they call them distributees in New York. It's basically a fancy word for next of kin. So if you are a single person with 3 children, your 3 children are your distributees. You would need to get permission from all of them in order for a will to be granted probate. And if you are disinheriting somebody or someone does not consent, then they get invited to what I call the probate party on the citation return date. And they have to say, hey, I either consent, object, or if they don't do anything, they consent, but you have months of delay. Whereas a trust, if your assets are in the trust, then at death, the successor trustee shows a death certificate and they begin administering the assets as soon as your death certificates are available.
So like the probate we just did for a client that took 3 years, I think?
About 3 years.
But that was because the owner passed away, had no wife, no kids, no spouse, wasn't married, not married, no kids, had 5 or 6 siblings, 4 out of 5 died, I believe. Out of those 4 that died, they had spouses and kids. I think there was a total of 30-something people we had to serve.
Correct, 30-something distributees. So that's another reason to use a trust is when you do not have close direct relatives. So if you are like this case, who are only grandnieces and nephews and siblings, when you're down to that level and there's that many distributees, a trust is more effective because then you do not have to hunt them down and get their consent.
Right.
With the trust, if that property was in the trust, the successor trustee could have just continued along and sold the property immediately. Or even if the trustee had died, they could appoint a successor. It would not have been a 3-year multi-year court process.
Right. Okay. So are there any other specific situations where a trust would be clearly better than a will?
Yes, there's a few categories. One, where you have minor children. If you go through probate with a minor, the court will appoint someone called a guardian ad litem. And that guardian ad litem does their own investigation to make sure everything with the will is on the up and up. There's no reason to challenge it on behalf of the minors. And that can add a good 2 to 3 months to your probate proceeding. And a guardian ad litem fee on a non-contested matter can range between $1,000 and $3,000 on average. And if it's contested, it can go into the tens of thousands of dollars.
Right.
Same thing with you have a disabled beneficiary, someone who requires a guardian, someone may have autism who cannot advocate for themselves. That similar guardian ad litem will be appointed. If you do not know who your relatives are, that's a big one. If you do not have relatives that you know about, and maybe your nearest relatives are cousins, you have to then find all your relatives on your maternal side, your paternal side, get jurisdiction over all of them. Sometimes you have to publish, and if you don't know who they are, the court will appoint a guardian ad litem for the unknowns.
Right.
And that, again, similar, another couple of months and another couple $1,000s in fees.
Right. And that's when they're starting to serve them with citations.
Yes.
So can you explain what happens if somebody doesn't answer when somebody's filing a probate will or trying to go through administration, which we'll get to in a little bit. But what happens if one of the family members just doesn't respond at all, doesn't sign the waiver, and just says, I don't want anything to do with this, and just kind of walks away?
So on a probate or administration, if you are served with a citation and you do not appear, that means basically you consent by default.
Right.
So whatever proceeding has been commenced will go through without you being a part of it.
Okay. And it could take a few more months because you have to wait for the citation date to pass from the court to issue the
Yeah, you have to wait
publication.
for the court to issue the citation, then you have to serve it, and then you have to appear, which is usually another 6 or 8 weeks after the citation is issued. And then afterwards, you have to wait for the letters to issue. So again, months.
Yep.
And also on an administration, the court will often set a bond if there is a non-consenting party to
Yes.
protect their interests. So that will also add expense.
Yes. We've dealt with that as well. Okay. So what about a living trust? Who would benefit most from having one of those?
So the people who should avoid probate. I mean, generally, just about everyone can benefit from a living trust because avoiding probate will avoid delay, expense, and time. But if you have a traditional family situation, probate is not the worst thing in the world. But for many people who, again, have minor children, disabled beneficiaries, do not know who their relatives are, those are or you're disinheriting somebody, those are the people who I would strongly recommend a revocable trust.
Mm-hmm.
Those people all can do wills, but expect the delay, complication, and expense.
Right. Because then you're leaving it more up to surrogate court's judge to determine, okay, what's the outcome of this estate going to be, rather than the trust says, okay, this, that, and that, no ifs, ands, or buts about it, and that's it.
Yeah, in the probate sphere, you have to invite all the relatives to the party.
Mm-hmm.
In the trust, it is more work for them, and they have to start the party. So to contest, they'd have to file a proceeding to contest the will or contest a trust, rather than if you have a will, you invite them to say, hey, here's my will. What do you think about it? The trust, they have to do their own work.
So what if somebody has a trust but no will?
Most people generally have a pour-over will and a trust. Usually it's part of a whole comprehensive plan. You fund your trust, and then your will deals with things that you may not know about. Sometimes people don't know they have it. They have little assets. They inherit assets later. So the will deal with anything you do not fund the trust. But it just says give everything to the trust. The trust is what governs.
Okay. Now, where is this trust located?
Usually the client will hold their own revocable trust. We will execute 2 copies, so sometimes we'll keep one, the client keeps one. But most people don't need to see the originals, but you do need to have the original.
What if the client loses it?
That really depends on the financial institution, because some financial institutions want originals, some will take copies, some will take affidavits that the trust is still in full force and effect and have not been revoked.
So does the law firm hold on to it for a certain amount of years?
We will hold on to it basically indefinitely.
Okay. And then, because this has happened also as well, where I've had clients say, oh, this attorney did this will 10 years ago. They only have a copy of it. They don't know where the original is. It wasn't filed in surrogate's court. We go to the attorney. He's either deceased himself or out of practice, and we can't find who took over the practice. So what do you do if there's something called like a lost will or a lost trust? What's the way to get around
So
that?
a lost will, you have to overcome a presumption of revocation if the decedent had it in their possession. But if you know an attorney had custody of it after a signing and you can't find them, then you can proceed with a lost will. You just have to get something from whoever took custody of that attorney's records that I don't have it, and just prove that it was never in the decedent's possession.
Right.
Because if they could, someone can't revoke it for them. They'd have to revoke it themselves. So attorneys dying, firms merging, changing hands does not make a will revoked, but it does have extra time and complication because then you have to do add language to your petitions, waivers, and there's extra work in the decree, and they have to go up for decision to the law department, which adds at least 60 days to your proceeding, where a traditional, if you have the original, doesn't require law department involvement. So it's an extra delay if you have to probate a lost will. It can be done, but there's some extra qualifications.
Another thing I've come across is that people have wills who the executor, who's going to be the named person that's going to handle the estate, may not be a relative. Maybe it's a friend, a neighbor, an employee, or so on and so forth. What happens then when we go to probate that will, and what happens to the rest of the family if they, they can contest it, they could come to it, but sometimes I feel that it may not be able to administer with the court. Sometimes they frown upon it, that like, oh, well, why don't you have a family member stepping up,
Yeah, the relatives, there's a saying that one of the former surrogates, you have a right to contest a will, but do you really have a reason? And the courts are very hesitant to disturb a choice of executor. I mean, you might not like it, but again, is it worth contesting? And some families have to figure that out because a will contest can cost up to $100,000. Right. And unless there's something seriously wrong with that executor, they're probably going to keep them in, and they're probably not going to get rid of them. I mean, a nice way to do it would be to try to negotiate maybe someone else serving with that executor, because if there's agreement from everyone, you can almost accomplish anything. Right. You would try to have a checks and balances system, but trying to remove an executor prior, unless there's felonies, financial issues, it's very difficult.
Okay, and then what about if the will or the actual document, the original, is not intact? And what does intact mean?
So a court requires a will to be stapled, and you cannot unstaple it. And if you unstaple it, then you have to do an affidavit saying that this is all the pages, it was unstapled, usually to make copies. Most people like to make copies and scan it. And then it wasn't amended or revoked or any changes made. So you have to be able to tell the court, someone has to sign that says, all the pages are here, I didn't alter them, and nothing was removed. So funding a trust involves changing the title on your assets. So instead of your bank account being in, say, Eva's name, it would be the name of the Eva Trust, or whatever you name your trust. You can name your trust whatever you want. So you would go to every financial institution and say, I'd like to change title, change of ownership that forms to my revocable trust. Or some assets where you don't change the owner, you can also just designate the trust as a beneficiary. So you have to do something with your trust. It's not an automatic. You have to fund it. Mm-hmm. Otherwise, you'll go through probate and then fund it, but you've almost not really accomplished your goals of trying to avoid probate if you don't actually fund your trust.
So if I forgot a bank account or a life insurance policy or something to put in the trust, then I pass away, then what happens?
Then we'd have to probate your will.
And go through the process anyway.
Go through the process anyway, but just for that one asset or two assets rather than everything. So at the very least, you would have, say, money in your trust from the other assets that funded it to do the bulk of the administration. So having a partially funded trust is better than having a not funded trust, but obviously it doesn't accomplish all the goals.
Okay. And speaking of funding, so talk to me about fees and things like that in terms of putting a will together versus putting a trust together.
So a basic will, usually we do them with healthcare proxies, power of attorneys, living wills. That's about between, about $2,500 generally. Trusts, revocable trusts, single to a married person, about $5,000 to $7,500. At the end of the day, though, a will is cheaper now, but more expensive later.
Right.
Because a probate proceeding costs at least $3,500. There's a court filing fee if your assets are over $500,000. It's $1,250 just to get in the door.
Yes.
So then you've spent the difference. And all the things that the court may ask you. If you have to appear on a site, or an attorney has to appear on a citation date, that's a good 2 hours of time. That's another $1,000.
Right.
So, for certain families, wills are okay. They're never the best choice, but it's not a ton of extra expense. But if you have to appear on a citation return date, you have $500,000, $100,000 more in assets. There's thousands of dollars you've just spent on a probate.
Right. And we touched on it before. You mentioned the word bond. Can you explain what that is and why we need one sometimes?
So bonds are usually used in administration proceedings when they have distributees who cannot consent or do not consent, or some courts just like them. A lot of the courts in the city seem to like to have bonds issued. It's an insurance policy to protect the distributees or creditors. And there's an annual premium. So your administrator has to have good credit, no bankruptcy. So that's also something to be aware of if you're going to need to get bonded. Or if you see a contested estate situation coming up where you think there might need to be a bond, you're going to want to see if your client can be bonded before filing.
Yes. We learned that one the hard way.
Yeah, you don't want to have somebody say, oh, this one's going to serve, and then you run their credit and the bond company's like, no way.
Yes, that's happened.
Yes.
Okay. Now, say we go to sell a property, we go through the probate, administration's done, but that's the only asset, and they had a bond. They needed a bond because one of the heirs or the distributees didn't sign one of the waivers, or the court required it. How do you then go about canceling a bond after everything's been closed out, and is it possible?
So you have to first talk to the bond company because every surety has requirements to cancel bonds. And depending on the dynamic, sometimes you will have to file for an accounting with the court to get a discharge. Then everyone gets notice, an opportunity to object to the accounting, and then the court will discharge the fiduciary on the bond. So
Right.
every bond company is a little different. If everyone's cooperative, you could try to get releases. Otherwise, if you can't, then you have to go back to the court with, again, more expense, which would be avoided in a trust.
Okay. All right. Is there anything else we may have missed on trusts or wills here? I mean, I feel like we've done a lot. We've gone through a lot together, and it's one of the things that is a blessing and a curse sometimes. If somebody has a will, and they don't have any other assets, maybe except for the property, then it's kind of like an extra time layer added onto it.
Yeah.
Versus if they didn't have one, they could sell the property quicker if they had all the heirs of the estate on board. But that's not always the case. So sometimes having a will is better in a situation where you have other assets that you want to protect. And if, in my case, and most of my clients' scenarios, if they're in foreclosure and there's a will, it's almost like they have to do this whole extra added step that they can't afford. So then it becomes now either the buyer or the bank's expense to now have to probate the will, which will happen, and they will reimburse some of those fees, which they just did on that case that we just completed.
Yes.
So, and then as for trusts, personally, I got one, and I highly suggest other people do it because it will save everybody a lot of headache from the time when their time comes.
And it allows the successor trustee to act basically immediately without all of these court delays.
Right, from like day one.
From day one. Yeah, you get a death certificate, you can move. And that's
Right.
the key.
Okay. Now let's just discuss probate versus administration, executor versus administrator, any other terms I'm leaving out here because people are always misusing them, and I just kind of want to clear up what these things are because it's not common language most people talk about.
So executors are appointed when there's a will, and administrator is appointed when there is no will.
Right.
Their jobs are very similar. The administrator is basically, you act under default. Because New York law basically says if you die without a will, these are the people who are eligible to become your administrator, and these are the people who are going to inherit, and these are the statutory powers. So the administration is basically the state determining on your who do you love list and who's eligible to serve. And basically, it's the default.
Mm-hmm.
Probate and the executor is governed by the will. So the executor, most likely, if it's a decent will have more powers than the administrator, more flexibility, and you can create trusts under a will for your beneficiaries, where the administration, they get it outright, that's it.
Right.
Which is also not a good idea if you have a special needs beneficiary, which could harm their benefit eligibility.
Right.
So in all wills and revocable trusts, I always encourage someone to have a special needs trust that's triggered, because you never know. And we live in the world of you never know. And
Yep.
someone even have an accident and be disabled later and need Medicaid. You always want to have that to protect anybody's benefits.
So you include that in the trust
In the wills and the trust, yeah.
and the trust. Okay. So what is administration? How is it different from doing a probate?
Administration and probate have similar procedures in the sense you file petitions for both. Administration, the filing fees are the same. So that court process is similar. You have citations for people who do not consent. The real difference is the administration, the court has more leeway on bonding, because the court will say, well, this one didn't consent, we want a bond. And the probate, if someone defaults, that's it. And if the will says no bond, no bond.
Right.
So it's really, you're leaving more up to default with the administration.
Right. It's in the court's decision. So now what if somebody inherits a property without any equity in it? They owe more than what the property's worth, and maybe there's a reverse mortgage on it or some other mortgage or liens or judgments, and the person passes away with or without a will, and it goes into the estate. What happens then? What are the options for the family members to do with it, if there is a will or not? And will they be responsible to pay that money back?
So the family is not responsible for paying the debts unless they receive assets of the estate. So just because, say, mom died with a house underwater, it's not your problem per se. You don't have to pay the bills.
Right.
Plus, she has $1 million bank account and you keep it and then don't pay the bills. You're only responsible to the extent you collect assets.
Okay.
I would always get in touch with someone like Eva if I had a house underwater, because a lot of times people don't know what to do with it.
Yes.
So, and people don't want to be bothered unless they're going to get something out of it.
Right.
So,
And most of the time, the heirs or the family that I speak to are like, well, I don't want to get involved. I don't want to be, liable for the money that's owed here. I have nothing to do with this house. My father got remarried, or, the wife's taking it over, and I don't want anything to do with this. I don't want to have to get this on my record and my credit. And what advice would you give them?
that it's not their credit that's endangered, but you should get it off your back, because the mortgage companies will foreclose at some point, and they will send you letters. They will serve you with process at your house. You will be getting notifications about this foreclosure forever, basically, years and years and years. Because
Right.
foreclosures can go on for years.
Yep.
And if you don't do something about it, the court will basically appoint a public administrator to accept service on your behalf, and you have no say in anything.
Yep.
If you do not become the administrator or do something. So there are things you can do. Eva is the pro on what you can do, but the default is usually not a good option.
Right. So just to clarify, they will not be responsible for the debt. It will not go against their credit, and they will not be personally liable for anything if they are selling the property on behalf of the estate, or if they become the administrator or the executor and go through probate or anything like that.
Correct.
Okay. And so now, what happens if somebody dies without a will? What happens to their estate?
Their estate will go through administration.
Right.
And basically the law will say there's two statutes in New York. EPTL 4-1.1 says who inherits, and SCPA 10001 says who can serve. Between those two statutes, who's eligible to serve and who gets what, that's determined. So you don't have a say. If you didn't want to leave one of your children anything, you don't do a will, well, they're getting something. It's default.
And that's called law of intestacy?
Law of intestacy. Yep.
Okay. And then what are the most common delays or pitfalls that family face in probate? With everything that's been going on with the court lately and probate court, and I kind of feel like every time, even with some of other cases that we have, one clerk will tell you one thing, you send it in as they said, and then another clerk tells you another thing. What actually happens when you're going through administration or probate on the court side of things?
So on the court side, they want you to submit your whole petition together. So you submit everything you have, 2 to 3 months sometimes, then it's reviewed, and if they want corrections, then you submit them, but then it's another 2 or 3 months. And then you have a citation if you don't have everyone's consent, and then that's another 8 weeks out down the line. And then you have to submit a decree, and that's another month or 2. So The biggest problem is delays of the courts. They're backlogged, they're short-staffed. It takes a long time. And even in a traditional family situation where there's no particular reasons to avoid probate, it's just slow. And also, again, that extra $1,000, over $1,250 filing fee for people that you wouldn't have in a trust.
Right. So if you did a trust, you would avoid waiting.
You would avoid waiting. Yes. And there's also, I forgot to mention earlier, small estates where if you only have $50,000 or less in personal property, no real estate, if you maybe forget a small bank account, there's an abbreviated way to go through what we call probate. It's not exactly probate, but to get appointed to collect those assets. And that filing fee is only $1.
Right.
So hopefully anything you leave out's worth less than $50,000.
Right. So in some of my clients' cases, we find that they do voluntary administration before small estates because they figure, oh, well, the house has no equity in it, so I'm just going to do a small administration. But then what happens when they actually go to sell the house?
The title companies will want letters issued if they see that small estate in the courts.
Right.
So then you have to convert it. So what you have to do is then file what's known as a report and account, report to the court what you collected as the voluntary administrator, submit your probate petition, and basically ask that the voluntary administration be revoked.
So do the whole thing over again.
Start all over again.
Okay. Are there any examples of how probate may have caused issues for families or how planning could have avoided that?
I see this with special needs individuals. If you have no will, the distributees just get it outright. And if you have Medicaid or SSI, that can create a problem because the SSI asset limit's $2,000 and Medicaid, it's about $32,000. So even a relatively small inheritance can knock someone off their benefits. Hopefully, if the person's under 65, you can create a first-party supplemental needs trust for them and move the assets. But that would involve, if they're really disabled, you might have to appoint a guardian and then a petition and proceeding to create an SNT. So that disabled person would have 2 extra court proceedings if there is no trust.
So a guardian to become appointed for somebody who has special needs, what is that process like?
So for a guardianship, you have to submit a petition under Surrogates Court Procedure Act Article 17A if the person's developmentally disabled. You have to get doctor's affidavits, consents from the adult siblings if there are any, and the guardian has to go through a background check. And depending on the level of disability, the court may appoint a guardian ad litem to investigate, or if there's any past criminal convictions, CPS reports, a guardian ad litem will be appointed to investigate that. And that could easily be another 6-month process.
Would a parent be considered an automatic guardian of a special needs child or a child that's turning 18 even?
So a parent is guardian of the person until they're 18. After 18, the parent is technically not the guardian anymore. And a parent can receive under the law up to $10,000 for the benefit of their child under 18. But above that, you have to apply for a guardian.
So if somebody has an autistic child who's non-speaking or nonverbal, can't make decisions for themselves, and it doesn't look like they will, what do you suggest that they do?
So before you pass away, you would, with your estate plan, you would have a guardian appointed, basically as soon as that child turns 18.
Okay.
A lot of the doctor's offices will let you slide for a little bit, but if you change physicians, you go to an adult family medicine practitioner, you change doctors or something happens, they're not going to talk to you.
Right.
Health insurance companies have been known to not speak to parents about insurance issues or medication issues. The pharmacy might not talk to you if there's an issue. So having those letters of guardianship allow you to basically continue to do what you were doing. If not, you can be denied access to information and to make decisions.
Would they have to go through the entire guardianship proceeding like anybody else would if, say, you had an elderly incapacitated person?
There's 2 different types of guardianships. The developmentally disabled would go through the surrogates court. The adult who has dementia and who once had capacity and then lost it would go to the Supreme Court in an Article 81 guardianship. Sometimes there can be some crossover depending on the level of capacity of, say, the autistic individual. Sometimes they just need a little help. Sometimes they need something full guardianship of person and property. So it's really dependent on the person.
Okay. And then what's the difference between a power of attorney and a guardianship?
The power of attorney, if it is a good comprehensive power of attorney, will eliminate the need for a guardianship. Because in a guardianship proceeding, a defense to needing a guardian is having a power of attorney and a healthcare proxy.
Right.
The combination of those two can avoid a guardianship.
Right. Now, I also hear people say, oh, well, they passed away, but I was their power of attorney, so I can make decisions on their behalf. What do you say to that?
Power of attorney is a piece of garbage after death.
After death. Right.
It does nothing
So it's only good while they're living.
while they're living.
And someone can give somebody else power of attorney for what decisions to make.
A lot of times it's power of attorney are generally financial decisions. So depending on the comprehensiveness of a power of attorney, the agent could sometimes even create trusts for that person. So, but the power of attorney, the big thing is a power of attorney cannot alter somebody's estate plan. So for example, if someone has a will that has two children as a beneficiary and they want to avoid probate, okay, you can create a trust, but those same two people still have to be the beneficiary. You cannot say, I don't like my sister, she's out. You cannot do that as power of attorney.
Too bad.
I know. You could also apply for Medicaid as an agent under a power of attorney.
For an incapacitated person.
Yep.
Right.
You can also file taxes. That's a big one. You can hire home health aides. You basically step into their shoes with a comprehensive power of attorney. So there's a state statutory short form that has some general powers, and I'll say it's basic in the sense that some banks or financial institutions for more sophisticated transactions to make someone eligible for Medicaid or to do estate planning on their behalf will not accept the basics. They want very tailored powers to show that someone actually acknowledges that their agent can do these things on their behalf. Because banking powers, a lot of banks won't say to change a beneficiary on the account or retitle it into the name of the trust.
Right.
That might mean you can write a check and pay a bill, but it doesn't give you the more comprehensive, thorough powers.
Right. So now Medicaid. Can you just briefly explain the types of Medicaid and what the qualifications are for it for people that are either disabled, elderly, and the other types of forms?
Sure. So there are two general types of Medicaid, we'll say, for the elderly and disabled. There's community Medicaid, which is aides at home. And then there's chronic Medicaid, which is in a nursing home.
Okay. And then how do they apply or become qualified for them?
So for community Medicaid, there is no look back period at this point. New York has been talking about it for about 5 years.
What does that mean?
So look back means they'll look back to see if you transferred your assets to basically impoverish yourself to be eligible for Medicaid. Nursing home Medicaid is 5 years. Home care right now has no look back. So it means you can transfer assets 1 month and be eligible the next. That's aides at home. But aides at home, you have to then financially qualify and then medically qualify because Medicaid will send someone else to evaluate and then you have to enroll with an agency. So it's worth it if you need a certain level of care. If you need 2 hours a day, someone just to help you, it's generally not worth all the financial upheaval.
So how would you advise somebody if they have a house with equity, meaning they're going to walk away with selling the property with a large lump sum of money, let's say over $100,000 minimum, and they are elderly, they're retired, they only make Social Security every month of, say, $1,800. And on Long Island, we know that does diddly squat. So what would you advise that they can do or can they apply for Medicaid?
If they need help, they can. They would move if they have a spouse, you could transfer things to the spouse. If not, you would prepare what's known as a Medicaid qualifying asset protection trust. You would transfer the house, and then they'd be eligible the next month. You can keep about $1,500, $1,600 in assets now monthly, and that overage you can either put into a pooled supplemental needs trust, but you can also use it for if you have a secondary health insurance you pay for. There's some exempt assets.
Okay.
So an asset protection trust is a helpful tool to either start the 5-year look back for long-term nursing home care or to get assets out of your name to be eligible for home care Medicaid.
Now, what happens with people that have no equity in their property, they have a reverse mortgage, and they have relocated to, say, a nursing home facility through Medicaid, and Medicaid has now put a lien on the property? What can be done?
Medicaid can only collect if the house goes through probate. So there's something called estate recovery in New York, and Medicaid will only collect against a probate asset. So if you are on Medicaid, having your house in a trust or having some sort of joint ownership, depending on your family situation, will avoid the estate recovery. Right. But if there's, Medicaid's not going to collect before a mortgage. Right. So Medicaid might be out of luck.
Yeah, most of the time when we do a short sale, if there is a Medicaid lien, we'll have the short sale approval letter sent to the Medicaid people, and they say, all right, we're just going to release the lien because we can't collect.
Yes.
So that's normally what happens on our end. So how long does probate usually take? How much does it cost roughly?
Probate on the low end, 2 to 3 months. On the more normal end, 4 to 6. To get in the door, again, that $1,250 for most people on Long Island. And legal fees generally started for just probate about $3,500.
Right. And then a trust to put together, you would say costs roughly
Between 5 and 7, depending on if it's a married couple or a single person, and asset transfers. If you want us to help you, we can. It just takes a little longer and it might cost a little more because of the time involved with the financial institutions.
All right. So I think we pretty much covered trusts, probates, wills. Now let's move on to types of deeds. So we could talk about property, home ownership, and what happens when somebody passes away, how the deed is written, and what that means for the family when they inherit the house. And I'll just give you a quick example. I was just on an appointment with a house in Suffolk County here, and the owners were a married couple, both passed away. It was their second marriage. So the husband had 3 children from a previous marriage. The wife had 3 children from a previous marriage. One of the wife's children's living in the property, but the wife had passed away first. And then so the deed says as husband and wife with right of survivorship. So that meant that the deed goes over to the husband, correct?
By operation of law. Yep. Nothing has to be done. It is now the survivors.
So now the wife's daughter who lives in the property does not have rights to this house any longer, but she's living there. And basically the property is now going to be owned by the
Husband's estate.
right. So therefore they're the only ones with the decision of what they could do with the property, even though the wife's daughter is living there.
Correct.
Because of the way the deed was written.
Correct.
So now let's talk about different types of deed. We'll start with warranty deed.
So warranty deed is basically when you know what you're giving away or you're selling, and you're basically affirming that you own what you're giving away.
Right. Okay. And then a quitclaim deed.
You can have whatever I have. I don't know what I have or what I may have, but you can have it.
How about a life estate deed?
A life estate basically gives the life tenant the right to live there their entire life. They are responsible for all maintenance, carrying costs. They could even rent the property during their lifetime. So it is theirs during their life, but upon their death, it immediately goes to the remaindermen, as we call them.
And it could be anybody.
It could be anybody.
Okay. And then what about a transfer on death deed?
Transfer and death deeds are pretty new in New York. They're only a creation of the past year or two. So it's similar in functioning at the end to a life estate deed where the remainder men get it at death, but there's no life interest. So, a life interest, I should have gone back. A life interest, if it's sold, there's a value placed on the life interest and the remainder men. So there's a certain percentage that gets paid out to the life tenant and the remainder men. It's based on the age and the value of the property. There's IRS tables. It's a whole calculation. Transfer on death deed, the remainder men have no rights to anything during the life of the grantor of the deed. Mm-hmm. But transfer on death deeds in New York have to be recorded before they're effective. Whereas life estate deeds, as long as it's delivered, doesn't necessarily have to be recorded, even though it usually is recorded.
Right. So the transfer on death deed would have to be recorded before or after the person passes?
Before.
Okay. And if it's not, then it's void?
It's void.
Got it. Okay. Now let's talk about right of survivorship versus tenants in common.
So say even I own a piece of property, joint tenants with right of survivorship. I'm older, I die first, it's all Eva's. She survives. Tenants in common, if we own a 50-50 tenants in common, I could die, my interest goes to my estate. She dies, her interest eventually goes to her estate.
Okay, so you hold your
Piece.
ownership.
Tenants in common means you own your piece, it's separate, and it does not go to the other one by default, unless, you could do it in your will, but nothing according to the title.
So what would be the benefit of putting your house in a life estate deed or a transfer on death deed?
I don't generally recommend it for most people. It's only if you have a very traditional nuclear family situation where you know who's going to inherit it and the people who may also inherit it.
Right.
So I've seen some problems with life estates where, mom names her daughter as the remainderman. Daughter predeceases mom.
Right.
So daughter's estate goes to her spouse and the minor children. Then you have a whole probate mess on the other hand, and maybe your in-law, who you didn't love so much, now gets a piece of your property. Or they can say, oh, you're not maintaining it well enough, and try to sever your life estate.
Right.
So you're inviting a lot of unknowns with the life estate. You're leaving a lot to default.
So would you be able to avoid that by putting it in a trust?
Correct, because if that daughter died, you would probably say, oh, my daughter's interest would go to her children, my grandchildren. And you'd be able to keep the in-law out of it.
Right. So why would people choose to do this over putting it in a trust?
Deeds are cheaper than trusts. That's the real reason.
But then you pay for it later.
Generally, yes, you pay for it later. That's why it's one of those things in a very limited set of circumstances for a very small, like if you had a daughter who was single but maybe had a child or two, maybe.
Right.
Because then if she passed away, then it would go to her children.
Right.
And it's not really going to go anywhere.
There's less left to the unknowns.
Yes. And you'd also then make sure the remainder beneficiary has their own estate plan to follow. If the times I've done it, I've said, okay, now your child needs to have a will that says my interest in this property, even if you have a spouse, then goes to the children. You kind of try to work it out.
Right. So when would you use a quitclaim deed versus a warranty deed?
Quitclaim deeds are usually used in family transfers. When you say, I'm just going to transfer my interest to my trust. I know what I have. I'm not really worried about it. Or interfamily buyout. Warranty deeds are usually used in sales to third parties.
Right. Now, what happens if somebody transfers their deed to a third party but then doesn't pay off the mortgage? What happens to the other liens and judgments that are on title?
They don't go away. You take it subject to whatever's there. And that's why, doing these transactions with a real estate attorney or a professional is always, DIY deeds usually go wrong.
Correct.
DIY estate planning usually goes wrong too, because I've seen a number of, internet prepared wills that, they don't mesh with the beneficiary designations. I've seen them executed improperly. That's the biggest problem, is when you have an internet executed will, it's not presumed to be executed properly. And if you're trying to disinherit someone, or you have some sort of complicated situation, and then a guardian ad litem gets appointed, or someone does an examination of those witnesses, they could say, oh, I just thought I was signing a document. If they didn't know that you were signing your will, it's not valid.
Right.
So, it's, again, another penny wise, pound foolish, because you'll probably pay for it on the back end.
Right. So that would bring me to, the pros and cons of a life estate deed. It avoids probate, has potential tax benefits, nursing home costs. Can you just touch on a couple of the pros of even doing a life estate deed versus?
Yeah, the biggest one, you will avoid probate. And also you get a step up in basis at death. So those are the two big ones.
Right.
But with a life estate, you also have to make sure, if, say, you have a taxable estate, that, you have to make sure you realize that's includable in your taxable estate. Because sometimes people think, oh, I gave it away, but it's actually includable. Cons, you lose control. We spoke about that daughter who, predeceases her mom, and then part of mom's house goes to the husband who mom didn't like so much.
Right.
And then conflicts. If you leave it to 2 or 3 children as remainderment, they might not want to be partners in real estate together. So you're, again, leaving it to the default, and sometimes people are not good partners.
Right. Now, what if it's an investment property and not a primary residence, and it's owned by, say, an LLC, and the family is now having to discuss who's going to take over these assets that are owned by, entities that are not a personal name?
Okay. So your entity, you have to have a good operating agreement, number one.
Right.
They have to address what happens when someone passes and someone wants to get out. Those things in estate planning are crucial if you have entities. You need to have an operating agreement. You need to have an exit plan. You also need to know who can become a member of that LLC. Because again, if another one of your, if your siblings dies, do you want their spouse to be able to come in as executor of their estate? Do you want to have a minor child as potentially a member?
Right.
So those are things you have to, it's always about a good operating agreement.
And that's a good benefit of having a trust, right? Because then you could put the trust as the owner or the member
Correct.
of the LLC.
Yep, and that interest doesn't have to pass through probate.
Got it. And then, so we just spoke about the cons of the estate deed, loss of control. You can't revoke it.
Capital gains are a big one for the remainder beneficiaries
Right.
too. So if the life tenant sells during their lifetime, they will get their $250,000 capital gains exemption. But since it's generally not the primary residence of the remainder beneficiaries, they get no capital gains exemption.
Okay.
And also, then you take it at mom's cost basis. So whenever she purchased it. So sometimes you have these properties where people purchased them in the 70s or 80s for, what we call today nothing, or $40,000, $50,000, $60,000, and they're selling for $500,000, $600,000, $700,000. The remainder beneficiaries during mom's lifetime do not have a capital gains exemption. They're going to have to pay capital gains.
Right. So what if they have themselves on as the life estate deed or the transfer on death deed, but there's a mortgage on the property? What happens then?
So the mortgage will get satisfied first, and then everyone will get their share.
Does the person that inherits the property or is now the new owner have to pay that mortgage off immediately, or what happens there?
So if you sell it, the proceeds will get paid. But otherwise,
Right.
the remainder beneficiary would have to assume the mortgage. The technical thing you do is assume the mortgage.
Right.
If the bank allows you.
Right. So assuming a mortgage, what would that process be like?
You have to make an application to the bank. And they have to run your credit. They have to make sure you are eligible to, they want to have credit with you. Some remainder beneficiaries have not worked a day in their life, and some people can't afford it or they have bad credit. So, banks may not allow you to assume a mortgage, and they could commence a foreclosure at some point.
Right. But then if the person is the owner now on the life estate deed, the person that they inherited it from has passed on, and that mortgage is there, and that person can no longer pay that mortgage, the house falls underwater, they would not have to do a probate, right? They could just sell the property on behalf of the estate?
Correct. They could just sell the property.
Okay. They wouldn't have to go through probate or
No
anything
probate
like that.
on a life estate deed or a validly executed transfer on death.
Right. As long as it was done prior to their death.
Correct.
Okay. So now, how important is it to make sure that a property is titled correctly in a trust, and what happens if it's not?
So the title on the deed has to match the title of the trust. They have to match. If not, you'll run into title issues. And Eve is an expert on dealing with title companies. But if it doesn't match, they could say, this property's not in this trust. And they could make you basically go through probate to get an executor appointed to be able to pass title. Or they can make the trustee and the executor sign the deeds because they do not want to be sued later. It's a risk game.
Right. And I'm going to say that I more often than not do not see houses in trusts. And when I do, because it's not public knowledge, I don't even know half the time to who to reach out to.
Correct.
If they're not coming to me and I'm going to them for some reason because the bank is asking me to find the family or asking me to find who's the next of kin or who's in charge of this property. So if a family member is not aware that there's a trust or that they're not included in it, what can be done to figure out who is?
So the first step you would do is you could have a proceeding to compel production of the will. Usually where there's a will, there's a trust.
Right.
And that's a way to back in, because if you are, say, next of kin, you have a right to see the will. Even if you're not probating it, you have a right to see the will.
Right.
And then you could figure out, usually whoever did the will did the trusts, and you can back into it that way. Also speaking to siblings, relatives. Sometimes the deed has an attorney's name who you return it to. A lot of times that attorney did the trust or the will.
Right.
There's a couple ways to back into it.
Find the breadcrumbs.
Yes, and a lot of times it is a fishing expedition. If you just see that property's in the name of a trust, you have to back into it.
Right. All right. So I think we pretty much covered titles and transferring and deeds. So now family financial planning tips. What would be, you say, the first steps for a family who wants to begin planning their estate?
Figure out what's most important. So if you have minor children, it might be naming guardians. If you have millions of dollars, it could be avoiding estate tax. You could want to avoid the costs of long-term care, or you could avoid probate. Those are the big four goals I usually say. Mm-hmm. So figure out what are those goals. Because, I don't have a taxable estate, so I don't really care about the estate tax exemption. It's over $7 million in New York right now. And for most people, it's not their issue.
Right.
Many people, long-term care costs are the biggest stressor. Mm-hmm. And most people I find, don't mind spending some of their money on long-term care. People expect to, but they don't expect to spend every penny.
Right.
So a lot of times I speak with people about, okay, what do you have? What are your goals? And then we figure out, okay, maybe if you want to prepare Medicaid irrevocable trust. We put your house and maybe some money in there because people would know they want to leave something to their families. But, they're comfortable with spending, maybe I'll make up $200,000, but maybe not the other $600,000 they have. People want to know they're leaving something for their families.
Right.
And planning early for that is the best way to do it, because if you start these plans in your 60s, odds are you're not going to need long-term care. The odds are in your favor. But my conversation with someone who's 80 and has not done any of this planning might be, well, odds are you may need long-term care in the next 5 years. And it would be, okay, maybe put more of your money in if that's your goal.
Right. Now, if somebody has a property with, say, a lot of equity and they want to sell it, what would you advise that they do with the money? Is there anything that they could do to set it aside for future use for when they do need it, when they need that care or things like that? A lot of people are relocating now to Florida because their houses have gone up three times over. And instead of just blowing it, out on the beach bar or whatever, what would you advise they do with that money to protect themselves for when they're no longer able to care for themselves?
So again, depending on the age, I would say at least put a portion of that in a trust. You can also explore hybrid life insurance policies, depending on your age and your health, because some of them will say, for example, if you have a $300,000 death benefit, if you need long-term care, it'll pay from that death benefit towards your long-term care, and your relatives will get the rest.
Right.
So those are things, long-term care insurance. It's very expensive these days, but it's also worth looking at. I never just say, oh, you need a trust and don't explore those other options.
Right.
Especially if you're in your 50s or 60s. It's always a good idea to look at those things.
So when would be a good time to get life insurance policies, and what types?
It depends on your goals, because, in your 40s, you might want to say, okay, maybe a term policy. Sometimes you renew those, sometimes the whole life, but the older you get, the whole life, the premiums can skyrocket. Where is it worth to carry it?
Right.
So you have to speak to an insurance advisor to see what's best for your goals, because, when you're younger, you probably don't have as much money to spend on it.
Right.
So you want something that maybe is $1 million, $2 million, but not hundreds of thousands of dollars a year. Because I just had a client who died in his 90s, and he was paying, I think, $300,000-$400,000 a year for his life insurance policies because he was 97 years old.
Oh my goodness.
So for most people, they can't afford that.
Right.
So, younger people, a lot of times I'll see them maybe with one whole life policy and then a few terms to fill in the gaps. Okay, my kids will be in college by the time the 20-year term runs, and, I won't need that extra infusion. They'll be on their own.
Right.
So it's always good to look at your family and how old your kids are.
So now, what would a common misconception be that people have about estate planning?
That it's only for the elderly. For example, college students even need to do a basic, healthcare proxy power of attorney, because your mom can't call the health office and get any information for you once you turn 18.
That's right.
Mom can't do any banking for you if you're only on your bank account.
Right.
So even at 18 years old, those are the very basics.
Mm-hmm.
But, every life event, you should revisit your estate plan. You get married, revisit your estate plan. Someone passes away, revisit your estate planning. You have a child, you adopt a child, revisit your estate plan.
So any major life event, basically.
And if you've done your estate planning and no major life event, about every 5 or 7 years is a good time to check in. But, even these basic lifetime documents, healthcare proxy, power of attorney, 18 years old.
Right. And power of attorney, we didn't mention this before, but if somebody's elderly or incapacitated, they can't sign power of attorney anymore, right?
Correct.
So they lost their window.
You need to do it when someone has the capacity to execute the power of attorney.
So what happens afterwards? They become incapacitated. How can you make decisions on their behalf?
You have to get court authority, go to a guardianship.
Right.
And that is thousands of dollars. There is court monitoring of every expense. There's annual accountings. Mm-hmm. So the power of attorney can save thousands and thousands of dollars in guardianship fees.
Does a power of attorney ever expire?
Not generally, no.
Okay.
You can put restrictions in it.
Okay.
Or you can make it springing, only effective when you are incapacitated. But most of them do not expire. But there are provisions in some of them that say they do not supersede priors. You have to be careful if you execute a subsequent one to make sure it either revokes a prior,
right,
or make sure it doesn't revoke a prior, because some financial institutions want their own power of attorney. So you have to make sure everything's coordinated and working together.
Got it. Okay. Now, you said everyone should review their will, trust, or estate planning every 5 to 7 years or so,
That's general, yeah.
just in case anything changes. And we kind of touched on before how families can plan for long-term care with Medicaid and nursing home costs. Other than putting the money aside when they sell their house that just gained 300% of equity, what other ways would you suggest that they can plan for that type of care?
The other tool is the Medicaid Asset Protection Trust. You know, you can put assets in it. You can make that, a vehicle that will hold other assets. Maybe you're $300,000 in equity. Maybe you put $200,000 of it. You can get the income from it, and that you pass the 5 years and you don't need nursing home care. That's not an asset anymore for Medicaid purposes. So for a lot of people, if long-term care insurance is out of reach, there is usually something you can do.
So for somebody that has what we call equity rich, but not income rich.
Yep.
So therefore, for example, they have $200,000 of equity in their house, but they only make $2,000 a month on Social Security. You would say putting together a Medicaid trust?
A Medicaid Asset Protection Trust. You transfer that house, and then basically you're just about eligible for Medicaid.
Really?
Yeah. You can only have about $32,000 in other assets. Say you have a bank account with a couple $1,000. That's not going to make you ineligible.
But if you have equity from the house, you put it in that special trust, and then you won't have a problem getting Medicaid after you sell the house.
Correct, because the proceeds would get paid to that trust, and the trust remains the owner.
Got it. Interesting.
And that trust can also buy you a downsize. If you go down south and you buy a condo, that trust can own that property.
Right.
And it also can invest the assets in the name of the trust, and you are entitled to the income. And then you also have the ability to remove and replace the trustees and change the beneficiaries in case anybody gets out of line. So you lose some control, but not complete control.
So when in doubt, it seems trust it out, because it seems like that is the easiest way to handle all these issues.
It is. And you're leaving things out of the will of the courts and the timeline of the courts, and you're putting yourself in control, especially if you're also creating trusts for beneficiaries. Because under a will, I don't know if we touched on this earlier, if you need to name a new trustee, if you have a trust under a will, you got to go back to the court.
Right.
And if you have a revocable trust, a lifetime trust, the document will govern what needs to be done. And usually it's just a notarized document to change the trustee. It's not a court proceeding.
Why do you think most attorneys don't set up trusts for people and advise and just give them wills instead?
Wills are cheaper and they're faster. So that's the main. And also some people get a little cost. They don't know they want to spend the money right now.
Right.
So it depends. It's really we have a whole conversation about what are your goals,
Right.
and also what's your family dynamic. Because for some families, if you're married and you have 2 adult children, they all get along. You'll still have the cost of probate, but the cost might at the end be comparable. But if you are disinheriting one of those children, your probate's going to cost a lot more money than your trust will.
Right.
Or if you have a minor child, your probate's going to cost way more than a trust.
So basically, the more complicated your life gets, the more assets, the more people, the more, a trust would simplify it and make it more direct versus if you don't really have too much going on, and maybe it's just you and your spouse and you only have this one house, you may not need a trust because it might just cost more money than what you really need to spend at the current moment.
Correct.
Okay.
Yeah, and it's your goals and the who do you love list. If you don't have those direct relatives, though, a trust is always better, because I've been on the hunt for these. I have this estate where now I'm on the hunt for the first cousins, and the first cousins once removed. Once I had to do an estate that it was administered in the will under California law, and I had to hunt down the second cousins. So, they were all 90 years old, and, I have horror stories for days on the relative hunt down.
Right. Yep.
Then you have to do the publication. If you can't find them, you have to get some of them declared to be unknowns. And that's a whole nother, there's a publication, a garnet litem, months
Yep.
at minimum. And thousands of dollars. Sometimes some of the courts will even make you hire a genealogist. And in the city, the courts make you publish in the New York Law Journal, which can cost thousands of dollars.
Right.
So that's where if you don't have near relatives, closer than siblings, a trust is the best idea to avoid the probate costs.
Okay. Anything else we may have missed here? We talked about power of attorney. Healthcare proxies are good for people of any age, even from college age up. Paying parents with young children should include in their in their estate plan the nomination of a guardian.
Yes, so that's I'm glad you mentioned that. So the nomination of a guardian in the wills, once that will is admitted to probate, then that person has standing to go to the surrogates court or the family court and become a guardian. 'Cause otherwise, it goes by, again, default. And it might not be the default people, might not be people you want to have your children. And I could think of many families who, where either maybe your parents, they're elderly, they can't do it. Or someone's in a nursing home who's incapacitated. Or maybe your parents live across the country. Or maybe they live, maybe they're not even able to take care of themselves.
Exactly, right.
And if you nominate the guardian, that person gets the standing. And then there's generally it avoids this person told me I should be the guardian or I should be the guardian. And it avoids the fight about who should be the guardian.
And the nomination of the guardian would go in the trust or the will or both?
Both.
Okay. Any tips for blended families, second marriages that we just spoke about before?
Yes.
The Brady Bunches.
The Brady Bunches should have trusts. And the Brady Bunches should also have honest conversations. Because I find a lot of the litigation I see is about lack of communication.
Yeah.
And unrealistic expectations.
Mm-hmm.
So, people finding out things by surprise at death is never a good idea.
Correct.
So having trusts also where everyone has visibility, and making sure that the family knows this is what I'm doing. Because they find out by surprise that most of the assets are going to the second wife, they're angry.
Yeah.
And a lot of times people need to understand, okay, this is what I'm doing for you. This is what I'm doing for, my wife. There's also a New York right of election that you can't just give her nothing anyway.
Right.
Prenuptial agreements are great in second marriages too.
Mm-hmm.
Again, they set expectations. Because I've always telling people, clear is kind. If they know what to expect, there's less likely for dispute.
Correct. Right. And
it could be a whole nother podcast on second marriages. That's a whole nother.
Mm-hmm. Yeah, because what I've come across is that when someone passes away, right, in the state of New York, half the house goes to the spouse, the other half goes divided between all of the children.
Yeah.
And it's not the spouse of their mother. It's not whoever their mother. It's the current spouse. So,
Correct.
Yeah.
Yeah, and then you can have those other co-owners. There's partition actions and there's other ugliness that can ensue if they do not get along.
Mm-hmm.
So planning for that. Trust planning, maybe making neutral people trustees in those situations if there's a dynamic between the second spouse and the children that they don't get along.
Can the attorney be a trustee?
The attorneys can be a trustee. Is it something I personally like to do? No.
Another job.
And, it's one of those thankless jobs because somebody's always generally not happy. And
Right.
being an executor or trustee, you're a fiduciary. You have to do what's best for all the beneficiaries, treat everyone equally.
Mm-hmm.
And it's a lot of legwork, and it's really not an easy job. And at the end of the day, everyone can criticize everything you've done.
Yep.
So, people fight over being executors. It's usually a fight for control because no one actually really wants to do all the legwork.
Right.
It's a lot of running around. It's a lot of paperwork. It's definitely not a good job.
So as they say, plan early and often.
Yes.
Right? So try to get on this as soon as you can, at least discuss it with an estate attorney, know what your goals are, and have a conversation with your family and set the expectations of this is what's going to happen when I'm gone, and put the reality out there because we're all not going to be here forever and we need to plan accordingly so that we don't run into problems when we're gone, and make sure it's, losing somebody is hard enough. Having to deal with the mess they leave behind is even harder. So,
and I see a lot of clients who've either had terrible experiences and they're like, I don't want to do that again, or they've had good experiences and they're like, I want that to happen.
right.
And a lot people learn a lot. Sometimes it takes, unfortunately, the first death for them to learn about estate planning.
Yeah.
From losing a parent or a spouse, and people, it's better to do this thoughtfully rather than in crisis.
Mm-hmm. So that leads me with my final takeaway here. What's one action every person watching should take today regarding estate planning?
Well, estate planning is not only for the wealthy. I think that's a common misconception. I don't
Yep.
have a lot of assets. Well, you still have generally most people have relatives. People have something. And, whoever you want to get it should get it.
Right.
So doing that planning, even if it's as simple as beneficiary designations for some people,
Mm-hmm.
not leaving it to the default. Because if you don't do anything, the state's going to determine who gets it.
Yes.
Usually, and the state does not get it unless you have basically no relatives, but who gets it? And the default is not always what you like.
That's right. All right. Well, thank you so much, Kira. It was nice speaking with you. And if anybody would like to reach out to Kira, you can tell everybody how to reach you.
Sure, you can reach me at kreed@rmfpc, and my phone number is 516-663-6518.
All right. Thank you.
Thank you.